looking towards the witness, especially when they hold up a piece of evidence. That always engages the jury. They want to study it. They got to actually handle the gloves in their own hands and pass them around the jury box today. And I see one witness, the last one, Detective Long, he would actually turn and look at the jury when he answered the question. So that garnered a lot of nods and paying attention from the jurors as he spoke.
And so, Chinley, tell us what will happen this afternoon when the jury resumes their positions in the jury box.
Well, still prosecution's case in chief. We can expect to hear up to probably 6 witnesses that they plan to call today. Could be along the same line of evidence from search warrants and analysts who process evidence for Jimmy Rogers' home, Curtis Wainwright's home, as well as Mark Sievers. It is just anyone's guess at this point. That means you're just going to have to stay tuned and watch Court TV.
We sure will. Chinley Painter, thank you so much. I want to turn to a wonderful guest I have in the studio to help me break down what we're seeing in this trial. Joining us here, criminal defense attorney Marcia Minot. Marcia, always great to see you. Thank you for lending your expertise to us here at Court TV Live. What is jumping out at you in this case? I know you've been following it since it began. You followed the Rogers trial. What are the things that are really jumping out that may be, good, bad, sideways? Tell me what's speaking to you.
What's coming out is that the state has decided to go more technically before they go emotionally. And sometimes that could be a little bit slow for jurors because you could lose them in the weeds of all this critical evidence and laying foundation and that kind of thing that you're trying to get in. It might be that they're changing it from how they strategized in the Rogers trial, where it's like, let's tell the story. Who is our victim? How was she as a person? That kind of testimony comes in first. And it might make it a little bit more difficult to keep your jurors interested in this strategy that they're using now.
Right. Today was one of those mornings in court. I was chatting with Ted Rollins about it a short time ago, where it's necessary evidence. You need to get it in. But it's tough to keep jurors. And it was great to hear Chinley say that they seem engaged, and perhaps getting to touch some of that evidence and really view it closely and examine it might be helping them to stay invested in it, because it can be hard when things get a little too technical and you don't have somebody on the stand who is a fact witness who's telling you a story and really drawing you in and playing on your emotions, when it's just things like search warrants and items seized and all that can be tough, right? That's a challenge as an advocate. What do you try to do to combat that?
It's a huge challenge, but what you have to do is make sure you strategically intertwine your witnesses, just as Chandler was expressing that the state is doing. So you might call a witness that's going to give you some, for lack of a better word, boring information. And then you're going to call another witness that's going to be a little bit more interesting. So you might bring a family member in or bring Rogers' girlfriend in. So now they're interested because they want to find out, how does Rogers' girlfriend tie Sievers into this murder based on her testimony?
Sure. The conspiracy, I mean, this is just huge what they're alleging here, and they've got to make that link. So all this evidence today is so important to making that link to Mark Sievers. Do you think there's anything that could be helpful if he were to choose to take the stand and testify in his own defense? Could he potentially help himself in any way, in your professional opinion, Marcia?
It's possible. And the reason is jurors will sometimes want to hear from you. It's tough. I know we live in a society where you have the right to remain silent, but as a litigator, it's becoming way more difficult to have your clients just sit there and say absolutely nothing, especially when the charges are murder charges. People want to hear, tell me why you're not guilty. Tell me where you were. Tell me what happened, so that the jurors can buy into he's not guilty. The risk you run as a defense attorney by bringing him on and having him testify is that you don't know how he's going to do on cross-examination. And a lot of times you can make your case extremely worse if your witness falls apart while he's on the stand.
Absolutely. A big gamble. And with a case like this, with charges so severe, so much at stake, his life at stake, on the line, literally, with this case and whatever happens in the guilt-innocence phase, do you feel like it's best to make that decision right before the time comes, to plan for it and then wait and kind of weigh all the options, see how the state's case plays out. What do you think is the best strategy for the defense to employ there?
That is the best way to go. Prepare your client as if he or she is going to take the stand to testify. And then during the case, you can determine based on the twists and the turns whether you're going to actually have your client testify. Because if you'd use the other strategy, which is I'm not going to prepare you, we've decided you're not going to testify, and something happens at trial that requires that individual to testify, now your witness is not prepared.
Right, right. It's all about preparation and bobbing and weaving with what occurs. If they feel like, hey, it's better to hold back and keep him, put no harm, no foul, but you're right, you can't turn back once he's on the stand then. I'm wondering about, as I'm watching that video, as I was talking with you, Marcia, his preparation in terms of courtroom behavior. As an attorney, you're going to go over things with your client about how their body language is examined by the jury just as much as any words. And look at this clip right here, where he's smiling, appearing to be laughing. Almost looks like he has something, I can't tell if he has something in his mouth that he maybe, does it look like gum or coughed up? I'm not sure, who knows, but it looks like he's got something in his mouth. When jurors see that, is that a problem? If you're a defense attorney and you're defending a client, who's charged with a crime as heinous as this, facing the death penalty, and they're seen smiling, perhaps with something, in their mouth, does that show any kind of disrespect that could be, or could be perceived that way, even though it may not be intended to be that way, but could be perceived as such by a juror and maybe be problematic?
You can turn your jurors off based on your conduct. In fact, even your attorney's conduct at times can turn jurors off. So I always express to clients, look, you are on stage. See this as your day to shine. Make sure you're making proper eye contact. You no longer want to glare. You don't want to look mean. You don't want to scowl. You don't want to pretend as if it's funny. So that conduct right there, depending on what's going on in the courtroom, I would not have my client doing that. That is risky because you can lose jurors and they're not listening to anything else other than we think he's guilty because of his conduct.
Right. And on the other side of the break, I'm going to have to get you some context for when that was. I didn't see that moment play out live. I'm just looking at the clip, but we'll talk about that when we come back. Marcia Minot, you're going to stay here. We thank you for that. We thank you for staying with us at home. More live coverage of Florida versus Mark Sievers after this. And also, we want to let you know you can check out a brand new trial on demand. We've got it for you. Go to our website, CourtTV.com. It is the state of California versus Cynthia Summer. She was convicted back in 2007 of poisoning her Marine husband with arsenic to obtain $250,000 in veterans' benefits. But that conviction was then overturned 2 years later. You can watch California versus Summer right now. Just go to CourtTV.com, click on the Trials on Demand section. You are watching Court TV Live, your front row seat to justice. I'm Julie Grant. Welcome back. We're keeping an eye on the courtroom in Fort Myers, Florida for you, where this is day number 4 of Mark Sievers' capital murder trial. The jury is out on their lunch break. If you're just now joining our continuing coverage of the case, don't worry. It's not too late to get caught up on all the facts. Here is Court TV's crime and justice reporter, Julia Janae.
In the beach town of Bonita Springs, Florida, on June 28, 2015, a doctor, Teresa Sievers, was just arriving back home from vacation alone. She planned to go back to work to her busy private practice, but she never made it to the office.
She's dead on the floor, and there's a hammer at the side.
The next morning, police discovered her body and a bloody scene in her kitchen. The 46-year-old wife and mother was brutally beaten to death in an ambush attack, all while her husband, Mark Sievers, and their 2 daughters were states away in Connecticut.
This was a very safe neighborhood.
Her horrifying death shook the community to its core. Questions swirled as her family grieved.
It's a very emotional time for everybody. So we just ask, that everybody just keeps everyone in these circumstances right now in their prayers.
With no suspects and few leads, police interviewed those closest to their victim. More investigation revealed Teresa and Mark's marriage of 12 years had many layers. Teresa's obituary describes Mark as her loving husband. Friends and family said the couple had typical arguments, often stemming from their shared work. Mark managed his wife's medical office and was a stay-at-home dad. Teresa, the breadwinner, specialized in anti-aging and holistic care. Her practice was inspired by Eastern medicine. But Mark and Teresa's work relationship wasn't the only thing unconventional. Cell phone records and letters recovered by police detailed Mark and Teresa's open marriage, other sexual partners, and a fantasy Teresa had involving Mark's friend Curtis Wainwright. 11 days after Teresa's brutal murder, a tip from an informant took investigators to Missouri.
I seen like 20 SWAT guys or so. A whole bunch of jackets and flag jackets and a whole lot of rifles.
Their investigation led to a suspect, Jimmy Ray Rogers.
Asked us if we seen anything suspicious to give him a call.
Rogers lived in this mobile home park with his girlfriend Taylor Showmaker. She would tell investigators Rogers made an unexplained trip to Florida.
I asked him what he went down there for, and he said to make money. And then asked him how does he make money, and it was murdering Mark's wife. I said, did you shoot her? And he said, no. And I said, then how'd you kill her? And he made a stupid little chuckle that he does, and then said everything.
Neighbors pointed to another connection. Rogers was good friends with Curtis Wainwright.
He used to go over to Jim's all the time.
Police arrested and charged Rogers and Wright with Teresa's murder. But for the Lee County Sheriff's Office, the case was not closed. Mark Sievers fell under what Sheriff Mike Scott called an envelope of suspicion. Life insurance policies worth nearly $5 million only added to their theory about the sinister plot. Months passed, and Mark remained a free man, fighting to keep custody of his two daughters. Then on February 6, 2016, 7 months after Teresa's death, deputies would make their third and final arrest.
I think a lot of people have been waiting for this day.
Mark Sievers was indicted for first-degree murder for orchestrating the deadly scheme.
Wainwright, Jimmy Rogers, and Mark Sievers are locked up where they belong.
Police allege Mark conspired with Curtis Wainwright as early as April of 2015. Then in June of 2015, Wright solicited Rogers to travel with him from Cadet, Missouri to Bonita Springs, Florida to kill Teresa Sievers.
I never in a million years envisioned beating her to death with a hammer.
Did Mr. Rogers reveal his presence to you?
Yes.
How did he do that?
He appeared to my right and started hitting her also.
Wright took a deal and testified against Rogers in October.
Did Dr. Sievers die as a result of something Mr. Sievers did?
Yeah. He approached me and told me that he needed to have his wife killed.
A jury found Rogers guilty of a lesser charge of second-degree murder. What the jury didn't agree on is whether the state proved there was a conspiracy.
The defendant is guilty of second-degree murder. Conspiracy. Check only 1. The defendant is not guilty.
Now prosecutors look ahead to their case against Mark Sievers, hoping to convince a new jury that the out-of-town husband was a ringleader for murder.
What do you think so far? Let us know. In the meantime, I want to bring back into the discussion criminal defense attorney Marcia Minot. Marcia, before the break, we were looking at some video. I was asking you about client behavior and how you prepare your client not only for the possibility of taking the stand, but also how to conduct themselves in court in front of the jury. And if we could show that video, we were looking at this video. This was from this morning, and I mentioned before the break, I didn't see it play out live, so I wasn't sure what the context of it was, but it was noticeable to us as, oh, why is he laughing? So we checked with some in our newsroom, and apparently this was outside of the presence of the jury. He was cracking up at something one of his attorneys said. He's got something in his mouth, not sure exactly what, but looking very relaxed. They're much more relaxed than he has looked in front of the jury at times when he's furiously writing notes or whatnot. So they obviously didn't see that laughing, which is good for him because someone could perceive that as him thinking something is funny or whatnot. But again, wasn't in front of the jury. What do you think about that? Can that be distracting at times with a defendant looking down, furiously writing notes or appearing to be overly taking notes, maybe when it's not appropriate. Like I keep thinking of when his attorney was delivering the open for him, and his attorney's up there talking, and he's advocating on his behalf, and yet he's got his head down, looking at the paper and appearing to be writing lots of things. Your thoughts, please.
It's tough because you have to prepare your client. Once again, when people ask how do you prepare your case, it's three things: preparation, preparation, preparation. Your client needs to pay attention and make sure that you know your story. You've already told me your story. It's going to look as if you're distracted if you're taking notes. I am in an opening statement speaking about your life. So what are you writing? This is a story that I'm telling about you. You should already know this story. I can understand if there's notes being taken when the attorney is doing a cross-examination, because you want to be able to tell your attorney that's not true, please ask about this or please ask about that. But when it comes to an opening statement, you have to be cautious that your client's not paying close attention, making eye contact but not glaring, not staring, watching their body language and remaining quiet, not a lot of movement going on at the table.
Right. You make such great points, Marcia. And to your point about looking but not staring, not making anyone uncomfortable, that's probably got to be tough too, because you want any defendant to appear very attentive and invested in the case, especially when someone's being defended on innocence grounds like Mark Sievers is here, and to look at the jurors, to be looking at his honor on the bench and the other attorneys to being really focused, but not to the point that it becomes awkward that someone is staring, right? That's got to be a tough balance to strike too. What do you say to clients in regards to that?
I always say to them, just look normal, look natural. Think about yourself as a father, think about yourself as a brother, think about yourself as a husband, and just act your normal self. It's tough because a lot of times people have preconceived notions about how someone should look in a particular circumstance. And unfortunately, we're not robots, so one size doesn't fit all in how we respond to stressors. So I always try to remind my client, you're a human being first. How would you act if you were sitting in a presentation? Or how would you act if you were listening to a story or watching a movie? And give them some life experience that they can tie themselves to anchor during the trial and during those times when the jurors are watching.
It is such great advice. Attorney Marcia Minot, thank you so much. You're going to stay with us. We thank you for staying with us at home. We need to take a short break now. When we come back, my colleagues will be joining me for your daily sidebar. We're going to break down everything that happened in court this morning in Florida versus Mark Sievers. And also, we're going to talk about, is the state connecting the dots for this conspiracy that they're alleging? Back right after this. Welcome back to Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. Thank you for being with us on this Monday. As you can see, we have a camera live in the Fort Myers, Florida courtroom where defendant Mark Sievers is being tried, accused of the crime of murder. This death penalty case expected to get underway in just a few minutes. The jury's still out on their lunch break, but don't worry. As soon as testimony resumes, we're going to take you back into the courtroom live. In the meantime, I want to talk to my guests here in the studio. I have two special guests helping me break down all we're seeing in this trial. Attorney Marcia Minot, and Judge Gil Tucson. Thank you both so much for being here. Appreciate your expertise. So tell me, we were just talking in our daily sidebar, and I think this is a really important question. Because Mark Sievers wasn't there physically present when these murders took place, and the state is accusing him of murder, he can be convicted of that crime, even not being physically there, all because of this conspiracy. Do you think the state is proving the conspiracy between these three individuals well enough? What are you seeing that is solid evidence showing the jury that Mark Sievers was the mastermind behind this horrible plot to kill his wife? Judge Tucson, I'll start with you, please.
I'd say the phone calls, the use of the devices, the text, the messages, the coded messages. I think all of that is critical for the state to make its case, because even though he wasn't there at the time that the hammer, did its damage, he was intricately involved in the planning. And I think jurors want to know, well, how were you involved? I mean, if you are the mastermind, what are the details that you specifically thought of and were concerned about. So I think even though it's a tedious, slow, not the most exciting case, I think the state is doing what it needs to do to show all of the many details and to ultimately get it tied up for them.
Sure. And do you think, as far as advocacy goes, Marcia, is that a challenge for attorneys too? Let's say you're the prosecutor on the case and you have this defendant who wasn't there, but you want the jury to understand you can convict him of first-degree murder. Even though he wasn't there, it seems kind of counterintuitive, if you will. It seems like, how can this possibly be the case? But to make sure they, no, link up the law with the facts. Do you think that's a challenge for an advocate?
It can be, however, the state can overcome it by using the but-for clause. But for the conduct of this defendant, this victim would not be deceased. And once you can explain that to the jury and connect the dots with the testimony and the evidence and the cell phone calls and funds, if funds were paid to Rogers or to Wright that made it to Rogers, then you can connect and say, jurors, I need you to convict him because he is the mastermind. He is the only reason why our victim is gone.
Exactly. And speaking of Jimmy Ray Rogers, for this jury, I feel like all of this evidence that can be kind of dry and a little bit laborious to go through, if you will, is really important because it's bringing him to life. I mean, this guy, we're familiar with him because we watched his last trial play out. We know his role. We know all of that. But the jury isn't going to see him in the courtroom because these cases were severed. I think that's really important to remember. They would have been tried together if His Honor hadn't granted that motion to sever. What do you think? Do you think the state's doing an effective job, Judge, in bringing him to life as a bad actor in this plot?
They need to do as much as they can in terms of making references to the acts that he's done. So even though there's been a separate trial and we know what the outcome is, and presumably they don't know the outcome, they are curious about all of the actors. Only one of the actors is on trial, but what Rogers did and his contributions are very important to the state's case.
Right. What do you think, Marcia?
Well, it's important to make sure that the jurors know that the acts committed by the individuals connected together is the reason why we're having this trial. And if you can get that information to them through the evidence and the testimony that's going to be provided by the witnesses, I believe the state is going to be able to meet their burden of beyond a reasonable doubt, which is what it is in this situation.
I want to ask you both about the testimony we saw in the first trial, the Rogers trial, from Jimmy Ray Rogers' girlfriend, Taylor Showmaker. And she just knew so many things she could not have otherwise known about his trip to Florida and the payment to be part of this contract killing, I mean, is what it is. And she gave testimony very reluctantly, came in, was crying, couldn't look at him, so upset that she was being caught. The state, I remember one of the prosecutors had to go out in the hallway and literally escort her into the courtroom because she was that reluctant. This is video from the last trial. And she's also the mother of Jimmy Ray Rogers' child as well. So there's that connection. But she's moved on. She's married to someone else now. You can see the ring on her left hand. We don't know. We've been trying to, I keep asking our crew if we know if she's going to be called, and the state's being very tight-lipped. We'll see. I would think they would be calling her. I want to know what you ladies think in your professional opinions. To me, I felt like she was so critical as a link and really getting the ball rolling in terms of the investigation that I can't see how they wouldn't try to bring her into this again a second time. Your thoughts on what she may offer and what the state might try to elicit from her, Judge?
So it's like she certainly would be a compelling witness, and you would want to think that this jury would have the benefit of all that she brought, because much of, to me, the compelling part of her testimony, was credibility, and the jury is going to be told that they have to assess the manner in which a witness testifies, the means for which they're giving their information, how do they know, et cetera, et cetera. But having testified once and having been that compelling, whether or not she's going to be the same type of witness the second time, the jury is out on that. And so to the extent that there may be inconsistencies between the testimony, now that she maybe is calmer, is less attached to the defendant, all of those things are going to bear into what type of witness she's going to be this time. And so that's what the state is going to have to assess.
Sure. Marcia, any
I think she might make a better witness this time. And the reason is there's no emotional connection to the defendant in this case. Unlike in the other case where Rogers has a relationship with her, in fact, there may be co-parenting that takes place depending on how long he serves time. She's probably connected to his family. There might be grandparents on that side. So the emotion is very high in her testimony in the Rogers case. She might be a little better witness for the state this time because now she's not connected to Sievers. She can just testify the facts, strictly what she knows, and try to be consistent with her prior testimony so that she's not impeached.
Right, right. And speaking of impeachment, one tool that could possibly be used, we know that there's video evidence out there. She gave a recorded interview with police. It didn't come in the last trial because there would be a hearsay objection to that. She's going to be testifying live. That's what she did last time. We were talking in the sidebar, and I wanted to bounce this off both of you. From an evidentiary perspective, how could the state possibly get that in? And I was thinking effect on the listener is the only exception I could think of to the hearsay rule, where the state would be offering it, look, we're not offering what she said in that witness interview with police for the truth of the matter, just for the effect it had on the detective who did the interview and then what he did in his investigation going forward, like when she talked about them disposing of the blue jumpsuit on the highway. And okay, then the detective went and confiscated the jumpsuit in the exact spot where she said. Effect on the listener was the exception I came up with. I want to bounce this off you, Judge. What do you think? Would you?
I probably wouldn't let it in.
No? Okay.
That's what you
need. The hearsay objection.
That's exactly what you need to argue.
Okay.
But quite frankly, I wouldn't have granted that exception. So I wouldn't have let it in on that basis. So I don't know if there's another. I don't know if there's another basis. I mean, it's hearsay. So, you know, you can say, well, he's taking actions because of what he heard, but the effect is that the jury's going to hear it. And that's what we're trying to keep the jury from not hearing it. We want the jury to hear from the witness directly, not indirectly. So, you know, I don't know what Marcia thinks. But
I would still make the argument even before
effect
Judge
on the listener,
Tucson,
exactly. Would that be the argument you'd make? Effect on the listener?
I would make that argument. It's worth the shot, even if Judge Tucson's not going to grant my request. You know, Judge, this is not for the hearer. You know, the matter of certainty is just the effect on the hearer. Like, what actions did she take? You know, but I know Judge Tucson would deny that and say she can testify as to what actions she took. Counsel, I don't need to let in a video of her regarding, you know, what actions she actually
took. Love talking evidence with you, brilliant ladies. Thank you so much. You're going to stay with us. I want you to stay with us at home. We're going to squeeze in a break since the jury still isn't back yet. We don't want to miss a thing. Live coverage of Florida versus Mark Sievers continues. Also, a little reminder, I want to let you know that there's a new trial on demand for you to watch. It's on our website, CourtTV.com. It is California versus Cynthia Summer. She was convicted in 2007 of poisoning her Marine husband with arsenic to obtain $250,000 in veterans benefits. That conviction, though, was overturned 2 years later. You can watch it now on CourtTV.com. Back after this.
Tonight on Court TV.
We continue our live gavel-to-gavel coverage of Florida versus Mark Sievers, a man accused of orchestrating the brutal murder of his own wife.